Welcome back to the morning show here on Arise News. It's now time to take a look at news stories making headlines around the globe. Of course, we begin here at home, where more facts have emerged concerning the alleged failure of the First Bank of Nigeria to fulfill its part of a deal to fund the exploration and development of oil mining lease OML 120, contrary to the agreement it had with the management of General Hydrocarbons Limited, GHL. Also, the chairman of First Bank Holdings may face arrest for contempt of a Federal High Court Lagos Judicial Division and for flouting an order restraining the bank from taking any steps to enforce any security, receivables, instruments or finance documents or assets of GHL. But it was gathered that FBN went ahead by obtaining a court injunction purportedly freezing GHL's funds in all commercial banks in the country to the tune of $225.8 million in violation of the earlier court order. As a result, GHL has initiated contempt proceedings against the bank and its directors. Asides, Otedola, who is facing arrest for going ahead to get a Mareva order without disclosing to the court that the case had already been argued and determined, also facing contempt charges are the Managing Director, Chief Executive Officer, Mr. Olusegun Alebiosu, and other directors. So, of course, this story has, if I may say, has been trending. It's been all over all of the news platforms, all the media platforms, and I believe it broke at some point during the course of the day yesterday. And more information is now surfacing as to what really transpired.
Absolutely. Thank you so much, Vimbai. More details have emerged. Yesterday, we spoke about this during the news headline, the first time we're talking about it on the show. But I do believe that even more information is going to emerge, so we haven't seen the end of it yet, not at all. Now, the challenge with discussing this matter is that it is in court. The matter is in court, so it's sub judice. So I'll be very careful in the way that I comment on the matter so as not to run foul of the law. But let me start by that Federal High Court order to First Bank, which is now being raised as a point in terms of now them obtaining a Mareva order. I'll read that. It says, an order is granted restraining the respondent either by itself for acting through its servants, agents, assigns, privies, I believe we have that, affiliates, howsoever described, including any person claiming under its authority from making any calls or demands or taking any steps whatsoever to enforce any security receivables, instrument, finance documents, or assets of the applicant which have been charged as security for the facility agreement in respect of the applicant's operation of OML 120, including but not limited to the said letter and the amended and restatement agreement between the applicant and the respondent pending the hearing and determination of the arbitration proceedings between the applicant and the respondents brought pursuant to clause 12C of the agreement between the applicant and the respondent dated 29th May 2021. Now, this matter has been going on, now that more details have emerged since about 2020, when in that letter that we've obtained that was written by GHL to the CBN governor, asking him to wade into the matter as a result of First Bank, FBN's reluctance or breach of contract between both parties. It actually details, and this day newspaper has the details of that story, details what transpired from the perspective of GHL. Now, FBN on its own part has also tried to present its own side of the case, but like I mentioned, it would be very difficult to begin to make, to begin to bring out facts or begin to talk about it when the matter is still ongoing, the conversation is still on. Yes, that's what I was talking about. So you can see the order there. So what they're saying, and the reason why the headline talks about Mr. Otedola being at the risk of even being arrested is because he's run foul of this particular order. He's gone ahead to obtain an order despite the Federal High Court asking him to restrain or asking the bank to restrain from any further actions on GHL. But I think on a broader sense, right, because people can, the conversation, a lot of people have seen the details, have seen the letters back and forth, but I think in broader terms, what it does spotlight, and I think this is why this must be carefully managed, is the banking system in Nigeria. This is just an example of what perhaps transpires, especially because if you look at it, you see the relationship between Atlantic Energy, which was said to be to have the backing of the former Minister of Petroleum, Diezani Alice Madueke, and her counterpart, and how a bad loan, which they defaulted. The loan in itself was given without due process being followed. Again, yesterday when I was talking about this, I talked about strong governance within the banking system, because you're holding people's money in trust and it's important. And this is why the CBN must come in to see, the details and really what transpired. Beyond that as well, looking at the banking system, because the way the outcome of this matter would speak to a lot of things and perhaps even be an opportunity to regulate the way loans are approached, given, honored, and the likes, due process being followed. The second part would be agreements and contracts. In the letter sent to the CBN by GHL, it talks about how FBN has breached the contract of agreement. And then you begin to wonder why. I'm not in any place to determine why, because they must have their reason, perhaps when they're able to say their side of the story. But the truth is that there are losses that have been incurred. What was supposed to have been a contract entered into in good faith has now degenerated into what we see today. A defaulting, problems for the organizations, the signal to investors, because there were a number of investors and international organizations that were also involved who didn't get paid as a result of the breach of contract. And then you wonder, why didn't FBN honor its contract in terms of with GHL? The argument is not convincing. If indeed all the due process has been followed, why didn't they honor the terms of the contract? Then you begin to wonder, is there a story behind the story? What is the interest of FBN in this? Especially with the OML 20, what is the interest of GHL in all of this matter? So I think this story actually brings up more questions than clarity. And I do believe that in the next few days, we're going to see a lot more. But I believe that the way that this is handled has a lot of impact, like I mentioned, on the banking sector, investor confidence, the way that Nigeria is perceived, home and abroad, the justice system as well, and also the CBN, all in this matter. We see what the next few days would present to see how the matter would emerge.
Okay, what are the key issues involved in this? Boardroom politics at one level, 2, corporate governance issues at another level, 3, the judiciary. Now, when you run a business, you are involved in transactions with other people, and there may be issues that will come up. Now, under, what is it called now? Under the law, it's only the court of law that can determine all of that. The second thing is that this matter is already before the courts. So there is a limit to which we can pronounce upon it. In other words, there is always dispute in businesses. People invest, people borrow money, people say pay back, people say, well, the circumstances are this way, the other party says it is that way. It's only a court of law that can determine the matter, either through court process or arbitration. In other words, I'm saying that what has happened so far between General Hydrocarbons Limited and First Bank Holdings is not unusual. First Bank Holdings, the directors have a fiduciary responsibility to maintain standards and to protect shareholders' deposits. And also, the other parties who go to them also have the right to say we should be treated fairly. That is for the court to determine. It is not something we can determine on this table as journalists. That's number one. The other issue that I've seen here is about the Mareva injunction. Now, many Nigerians may not know what is called the Mareva injunction if they have not had the opportunity to attend the law faculty class. Now, what a Mareva injunction is, simply, as established in Crowder versus Crowder, is that it is a freezing order. Now, one party, the applicant, says, this other party has issues with me in terms of business transactions. Can you freeze the assets of this other party until the determination of a motion on notice? Now, it is within the rights of the applicant to do so. So you go to court and you say, grant me a Mareva injunction or a freezing order. Now, a freezing order does not mean that the assets no longer belong to the defendant. A Mareva injunction that was granted by Justice Dikpeolu will not say that. So it means it's still, your assets. But there are issues that we have to resolve. Those issues can be resolved either out of court or in court. So it can be by arbitration or in court. Number two is that a Mareva injunction can be granted by ex parte. So in other words, the court has not done anything wrong in this particular case. An ex parte injunction, an interlocutory injunction that have been ordered. Third parties can also be involved. And the reference, the locus classicus, I keep saying, I stand to be corrected. The last time I wrote a project on Mareva injunction was in 1999. So I may not remember all the details. But I say that, look, the third parties also have rights under that Mareva injunction. So that Mareva injunction was given by a court against GHL. Now, GHL has also acted within its rights to go to court. Under a Mareva injunction, if I remember well, within a week, you have to go back to court. And your solicitors, your lawyers have to be very smart. What are the options available to them? They will ask for a vacation of the freezing order, which is what General Hydrocarbons have done by saying vacate the order. Now, they can also ask subsequently for a variation. In other words, GHL has also acted rightly by not sleeping on its rights. Because if you sleep on your rights, you will lose the game. And also, third parties can also go there and say, look, we also have rights. How can you attach our own assets in a matter in which we are not necessarily involved? However, the Mareva injunction is the nuclear weapon of the law. It's called the nuclear weapon. That's why you cannot take it lightly. And this is the, the legalistic part of it, the legalistic part, to look at the matter. So, in other words, the matter still remains in court. Okay? Either it's a freezing order, or it's a vacation, or it's a variation. What the defendant will do is to look for an opportunity to stay within the province of the law. And that's why I say the solicitors, the lawyers, the counsel, to GHL, they seem to have acted appropriately. But that is not the end of the matter. So is this a matter that will go to arbitration? Is this a matter that will go into variation because there's room for negotiation? Or is this a matter that will die summarily? So what I see is that both parties involved are using their positions of strength and staying within the province of the law. I've not seen anybody doing anything illegal so far. It's for the court to determine that. But in terms of the processes under Mareva injunction or freezing orders, I think that both parties are, getting their lawyers to put on their thinking caps. And lawyers in a Mareva injunction matter have to be very smart. I hope they get good lawyers on both sides to argue the matter.
Absolutely, absolutely. It was Aliko Dangote who said that when Nigerian entrepreneurs get to the gates of heaven on Judgment Day, they will get an automatic pass to heaven because the Lord will just look at them and say, wow, I see how much you've already suffered on earth. And this situation reminded me of that because on both sides of this dispute, you have two notable and visionary Nigerian entrepreneurs. Now, when you look at the issues, there are questions here. Number one, of course, is the fact that in every transaction, in every relationship in life, there is room for dispute. It's normal, it's natural. Brother and sister quarrel, siblings quarrel, friends quarrel. So it's only natural that at some point in transactions, especially of this huge nature, I mean, we're talking a lot of money here, that at some point there may be disputes and misunderstandings. So there's nothing to, shall I say, breaking news about the fact that there is a dispute happening between two parties who are engaged in business. That's number one. However, when you now look into the details, you now say, First of all, there's the legacy nature of this dispute, which is that when you start looking at former ministers and their business entities, and how it is alleged that one transaction was created in order to try and ensure that the other didn't read badly on the books of the bank, it begs us to question about culture. If I was here, I'm sure he would say culture will eat strategy for breakfast any day. Because at the end of the day, you now look at the period of time that has elapsed and you now ask yourself, what is the culture that we're imbibing in our corporate governance? Because it's one thing for us to wake up every morning and to demand better from the government and to say we need governance. We need governance. But within our own spheres of influence, to what standard are we holding up our corporate governance? Now, this is not an indictment on any of the parties involved because, again, it's up to the courts to decide who is right, who is wrong, and how the issue will be settled. But I think it's an opportunity for us to reflect about how business is conducted, about the culture that we have created around transactions in Nigeria. Of course, globally it exists as well. They'll tell you that the easiest way to close a deal is to go and do it on the golf course. It shows you that it's not at boardrooms, at board tables that things are settled. It's on the sidelines of various other meetings and so forth. But are we holding ourselves to a better standard within our private organizations? To the same standard that every morning we wake up and we say we need government to do better. As private individuals, are we doing better? What is the attitudinal strength of our society when it concerns our attitude towards due process, respecting contracts, doing things in good faith, and of course, the pursuit of a just society? Because again, some people may say, wow, this issue has gone this far because these are two big men involved, but not just two big men, several big people involved. It made me think about the common man. And what happens to the common man when he has a dispute or an issue that he needs to take to court, and how long he will stay in the court, and if he can even afford appropriate legal representation? So there's so many conversations, so many questions for us to ask ourselves as we continue to sit and wait and watch for this dispute to come to its ultimate resolution.